imagine stepping into a courtroom where, like, the very act of defending your innocence is legally defined as definitive proof of your guilt.
Yeah, it sounds completely absurd.
Right, or imagine signing the most important contract of your entire life, only to discover years later that the whole legal architecture underneath it was secretly swapped out.
And swapped out for new rules that actively penalize the person who actually wants to keep the agreement.
Exactly. I mean, you'd probably assume you were living in some dystopian novel. But what if those are just, the standard operating procedures of a system you interact with every single day?
It's a terrifying thought, but it's grounded in reality.
It really is. And that is the core tension we are pulling apart in today's deep dive. We're exploring an explosive new ebook aimed directly at men's rights activists, the red-pilled manosphere, and honestly, any man who just wants to understand the invisible mechanics governing his life.
It's a dense, highly structured framework.
Yeah. The mission for you, the listener, is to understand the actual history of our modern institutions. We want to decode how they operate in reality versus how they operate on paper.
Which is a massive distinction.
Right, and to examine the author's deeply researched argument that these institutions were systematically captured by feminist and Marxist ideologies long before most of us were even born.
And the text fundamentally argues that the legal and cultural systems men navigate daily, I mean, from family court to corporate HR to modern therapy, they aren't malfunctioning.
Wait, they aren't, because they seem to produce incredibly skewed, destructive outcomes.
I know, but the author says they are functioning with perfect precision. They're executing a very specific historical and economic blueprint.
Okay, that's heavy. And the book breaking all of this down is called Divorce as Rite of Passage: Achieving Post-Conventional Self-Authoring Mind by Conrad Riker.
That's quite the title.
It is. I want to put this right out there, guys. The author positions this text as an absolute must-read survival manual for any man navigating the modern world.
Yeah, he doesn't hold back at all.
No, he doesn't. If you are tracking with the concepts we uncover today, you need to go buy the ebook right now on Amazon, Kindle, or Google Play Books.
Highly recommend checking it out.
Yeah, and make sure to follow the author at Conrad Riker on Substack. Also, be sure to like and subscribe to this deep dive so you never miss our future explorations.
Definitely.
Now, before we get into the mechanics of this, we really need to set a firm boundary, because this source touches on highly politically charged themes.
Very charged. Intense critiques of feminism, the family court system, modern sociology.
Right, so we want to make something crystal clear to you. We are not here to endorse or take sides on these viewpoints.
Exactly. We are just the messengers today.
Our job today is to impartially report on the exact content provided in this fascinating book, unpack the author's framework, and help you understand the very real ideas driving this massive cultural conversation.
It's about understanding the argument, not necessarily adopting it.
Okay, let's unpack this. The author starts with a concept he calls the secret rewriting of the marriage contract.
Yeah, so Riker's foundational claim is that the introduction of no-fault divorce didn't modernize the institution of marriage. According to his analysis of legal history, it completely abolished it.
Abolished it. That's a strong word.
He argues that the system intentionally kept the aesthetics. The wedding ring, the vows, the public ceremony.
Cultural vocabulary of permanence and sacrifice.
Right, but it completely gutted the legal architecture underneath. The author contends it turned a binding covenant into an open-ended liability.
How so?
Well, the crucial shift, like the mechanism that changed everything, is this. In standard contract law, if you breach an agreement, you pay a penalty.
That makes sense.
But in the new marital legal paradigm, the party who breaches the contract is frequently rewarded. They get the assets, the subsidies, while the party who wishes to maintain the contract is forced to pay the price of dissolution.
Let me push back on that framing for a second. Because if I think about standard business contracts, if two partners want to dissolve an LLC, there's a mechanism for that.
Sure, business dissolution is normal.
The author uses a business analogy, saying it's like a partnership where your partner can unilaterally dissolve the company, take the IP, seize the assets, and then legally force you to pay their ongoing expenses under threat of jail time.
Yeah, that's exactly his analogy.
But isn't that ignoring the fact that prior to no fault, people were essentially trapped by the state? I mean, trapped in highly toxic, sometimes abusive situations unless they could definitively prove fault to a judge.
The author actually directly addresses that historical counterargument. He doesn't deny that the pre-1969 system had friction.
Okay, needing grounds for divorce, like documented adultery, cruelty, abandonment.
Right. But he argues that this friction was the defining feature of a contract. If a party wanted to exit a marriage without provable cause, they had to negotiate an exit with their partner.
Oh, so they couldn't just walk away free and clear.
Exactly. That meant the exiting party risked losing primary custody, or maybe paying financial damages, or surrendering the house to buy their way out of the covenant.
So fault determined the economic and structural outcome.
Yes. And what happened when Ronald Reagan signed the first no-fault statute in California in 1969?
A model that, New York finally capitulated to in 2010, right?
Yeah, New York was the last holdout. What happened was the removal of that friction. Riker points out that removing fault from the legal equation didn't create some neutral, compassionate system.
It just shifted the power dynamic entirely.
It simply made breaching the covenant free for the person initiating the exit. And it loaded all the exorbitant structural costs onto the party who wanted to stay.
So the argument is that the marriage license transformed from a recognition of a united household into basically a jurisdictional trap.
A trap that could be sprung at any moment.
The text specifically points out that the divorce doesn't actually happen on the day a man is served papers at work or comes home to change locks.
Correct. The text maps out the timeline, arguing that the dissolution happens months prior.
Quietly.
Yeah, quietly. In private conversations, therapy sessions, initial legal consultations, the actual filing of the divorce papers is not an opening negotiation.
It's a procedural checkmate disguised as an opening move.
Exactly. The person who reaches for the legal exit first gets to entirely control the detonation of the household.
Wow. If we connect this to the bigger picture, actually, I want to look at the historical parallel the author draws here because it's fascinating.
The Roman Empire parallel.
Yeah, he uses the Roman Empire as a kind of prophecy for this exact legal shift. But how does ancient Rome actually map onto a 1969 California statute?
Well, if we connect this to the bigger picture, Riker uses Rome to demonstrate the predictable life cycle of a civilization that dismantles the marital covenant.
Okay, take me back to Rome.
If you look at the early to middle Roman Republic, marriage was a strict, legally binding institution. But by the late Republic, marital law had softened dramatically. Divorce transformed from a serious, heavily adjudicated act requiring valid cause into a completely unilateral declaration.
Meaning one person just decides it's over.
Exactly. Spouse could literally just send a written notice via a messenger. It's called a repudium. And the union was instantly dissolved.
Just a piece of paper delivered by a guy.
Yeah. There was no trial, no judicial oversight, no state interest in maintaining the bond. The legal mechanism of exit became totally frictionless.
And according to the text, what was the actual structural fallout from that? I mean, we have incredibly meticulous records from the Romans, so what does the data show actually happened to the society?
The outcomes were structurally devastating. Aristocratic birth rates plummeted. Prominent Roman family lines faded out completely within just a few generations.
So the core engine of society just stalled out.
Basically, the traditional family unit, which had historically been Rome's core engine for economic output, moral education producing reliable soldiers, it essentially emptied out.
And the state eventually noticed this collapse, right?
Oh, they noticed. Not out of a sense of moral compassion, mind you, but out of sheer bureaucratic panic. The tax revenue base and the military recruitment pools were shrinking simultaneously.
So nature abhors a vacuum. If the family unit is no longer executing those functions, welfare, elder care, education, someone has to step in.
And that someone was the state. Augustus Caesar recognized the demographic and economic crisis and tried to reverse it with aggressive legislation.
What kind of legislation?
He passed the Lex Julia and the Lex Papia Pavia. These laws literally impose financial penalties on unmarried men and childless couples.
Wait, a literal tax on being single?
Yes, while offering political and financial rewards for producing legitimate offspring. But Riker's point is that the cultural machinery of easy dissolution had already taken root.
The damage was done.
Once unilateral, frictionless exit was normalized, imperial decrees couldn't put the genie back in the bottle.
So the functions of the family were inevitably absorbed by the state bureaucracy.
Exactly. The cura annonae, the state grain distributions expanded massively. The emperor, culturally, became the father figure, the ultimate provider.
And the citizen just became the dependent.
The text argues that Rome fell because the load-bearing walls of the family were removed from the inside out, allowing the bureaucracy to hollow out the citizen long before the barbarians ever walked through the gaps.
Okay, if that absorption of the family's functions happened in Rome, we have to ask how that exact same mechanism operates today.
Which brings us to the economics of family law.
Right, because the core of Riker's argument isn't just that the culture changed, but that a massive economic engine was built to facilitate it. He describes the modern family law system not as a tribunal for justice, but as a revenue extraction protocol.
He is incredibly specific about the economics here.
Yeah.
The book states that the average family law case in the United States generates between $50,000 and $300,000 in legal fees per party.
I have to stop you there. Up to $300,000 in fees just to dissolve a middle-class household.
With contested matters easily crossing into the millions.
I'm looking at those numbers and struggling to see how a system even generates that kind of friction. How does a standard two-income family even afford to produce that level of legal billing?
Well, it's engineered through a mechanism the author calls the First Movers Massacre.
First Movers Massacre, what is that?
Riker explains that the system does not punish delay or conflict. It aggressively monetizes it. The friction is the product.
Right, so how does it start?
When one spouse files an ex parte order.
And an ex parte order is?
It's an order granted by a judge based solely on the claims of one party without the other party even present to defend themselves. It functions as a procedural ambush.
Oh, wow, so you don't even know it's happening until it hits you.
Exactly. The responding party is instantly placed on the defensive. He is immediately scrambling to find alternative housing, secure emergency counsel, and attempt to appear calm.
Which is hard when your life is imploding.
Very hard. And the system is already scrutinizing his visible distress as evidence of emotional instability.
So the panic is the point, and the clock immediately starts ticking on those billable hours.
It does.
Walk me through the exact arithmetic the author provides, because he claims this delay isn't a bug, it's the core feature of the protocol.
Let's trace the exact billing cycle Riker outlines. Petitioner files an emergency order on a Tuesday. The respondent is served notice on Wednesday afternoon.
Okay.
His attorney bills 4 hours immediately, just reviewing the affidavit and initial filings before even having a substantive phone call with the client.
So right there, you're down a few $1,000s.
Right. An emergency hearing is set for Friday morning. Both attorneys prepare. But on Friday, the judge's docket is overloaded, or opposing counsel requests a brief continuance to, quote, gather more documentation.
Just a simple delay.
That simple continuation costs nothing in court filing fees. But the respondent's attorney just billed for the preparation, the travel to the courthouse, and the time spent waiting in the hall.
Just sitting around billing.
Yes. The hearing is moved to the following week. That generates another 8 hours of attorney preparation time as circumstances shift over the weekend.
It's just a cash register ringing.
At standard billing rates of $500 an hour, that single procedural hiccup is $4,000. In major metropolitan markets, it's $8,000.
From a delay that wasn't even your fault.
Now, multiply that dynamic by a typical case lifespan of 18 to 36 months, involving mandatory mediation, discovery disputes, forensic accounting, half a dozen substantive motions.
The wealth destruction is absolute.
The marital estate literally collapses under the financial weight of the apparatus that arrived to manage its failure.
But wait, if you walk into any family court in the country, the phrase that is painted on the walls, invoked in every single ruling, is the best interests of the child.
It's their mantra.
Yeah. How does the author reconcile this universally stated goal with his claim that the system is just an extractive, wealth-destroying machine?
Riker dismisses the best interests of the child as necessary moral camouflage.
Camouflage.
He argues that you have to look at the outcomes, not the stated intentions. The immense wealth destruction inherent in the divorce process, the drained college savings, the duplicated housing costs, the massive legal debt falls heaviest on the children's future.
They're the ones who ultimately pay for the friction.
Furthermore, he argues the system professes to value fatherhood, but it structurally engineers outcomes that reduce a father to a bi-weekly direct deposit and an every other weekend visitor.
It physically removes the father from the daily routine.
Exactly. It guarantees his absence through custody percentages, and then crucially uses that very manufactured absence as proof that he is an irrelevant figure in the child's daily life.
It's a closed loop of justification. Create the absence, then penalize him for being absent.
It's brilliant, in a terrifying way.
And the psychological toll of this specific extraction process is catastrophic. The mortality statistics the author pulls in are genuinely shocking. How does he link the legal mechanism to the suicide rate?
He links it through the concept of absolute systemic isolation. The text cites data from the CDC's National Vital Statistics System.
What does it show?
It shows that divorced men between 45 and 64 commit suicide at nearly 4 times the rate of married men in the exact same demographic.
4 times! That's not a margin of error.
No, it's a massive spike. He further breaks down a 2013 study published in the Journal of Family Issues that found a 3.2-fold increase in suicide risk for divorced men, specifically within 2 years of separation.
Within 2 years, so right in the thick of the legal battle.
Exactly. Riker's analysis is that this risk peaks precisely at the conjunction of asset seizure, the finalization of custody loss, and reaching the saturation point of legal debt.
So it's not heartbreak.
He argues these men aren't dying of a broken heart over a failed romance. The psychological mechanism triggering the suicide is the realization that they have been trapped in an unnavigable, hostile bureaucracy.
A bureaucracy that has successfully legally mandated the destruction of their identity.
Yes, while simultaneously convincing society that the man himself is to blame for it.
But an extractive system that aggressive requires a massive, unassailable justification to operate in plain sight. I mean, a judge can't just forcefully remove a citizen from his home, restrict access to his children, and liquidate his assets without a profoundly compelling, legally sound reason.
You would think so.
How does the court justify granting these immediate structural disadvantages? What is the trigger?
This is where the text moves into what I think is its most complex argument. The weaponization of language and what Riker terms the epistemological coup.
The epistemological coup. Break that down.
The author argues that modern divorce proceedings, particularly in the initial phases, no longer adjudicate objective reality, meaning what actually physically happened.
Okay, so what do they adjudicate?
Subjective reality, meaning how the accuser felt about what happened.
But how does a judge accept a feeling as a legal fact? The court system is built on evidence.
That is the core of the epistemological coup. Riker points out that family court operates on a preponderance of the evidence standard, not beyond a reasonable doubt like criminal court.
It's a much lower bar.
A significantly lower bar. And in the modern era, subjective distress has been successfully commodified into an actionable legal asset.
An actionable legal asset.
The text details how deeply clinical psychiatric terms have been democratized, stripped of their strict diagnostic rigor, and handed out as legal skeleton keys.
What kind of words?
Words like gaslighting, toxic, narcissistic abuse, and coercive control are used to bypass the need for physical evidence.
Right, because everybody uses those words now.
Exactly. For instance, Riker argues that in a family court affidavit, gaslighting no longer requires proving a deliberate, multi-year clinical pattern of reality distortion intended to drive someone insane.
Operationally, it simply means he adamantly disagreed with my version of events.
Yes, and narcissistic just means he asserted a boundary regarding his own finances that I didn't like.
So, highly subjective, vague interpersonal friction is dressed up in lab coats, labeled as abuse, and paraded as expert testimony to secure a legal outcome.
Exactly. And because the court operates on a highly sensitized risk management algorithm that credits female fear and heavily discounts male objection, these therapeutic buzzwords instantly secure those structural advantages we discussed.
Like exclusive occupancy of the home or temporary protective orders?
Right, without requiring hard physical evidence or rigorous cross-examination before the order is granted.
This introduces a terrifying logical trap for the listener to consider. The author outlines an epistemic loop that a man finds himself in once these therapeutic accusations are formally made. It's essentially a legal Kafka trap.
The syllogism the book outlines is chilling in its simplicity.
Let's hear it.
Premise 1. The modern legal framework frequently defines male disagreement, or the refusal to accept a female partner's narrative, as a form of psychological abuse or coercive control. Premise 2. A man who vigorously defends his innocence against a false accusation is, by definition, disagreeing with the accuser's narrative.
Oh, man.
The logical conclusion. A man who defends his innocence is actively committing abuse by invalidating her lived experience.
Exoneration becomes logically impossible within the framework.
It really does.
If you fight the charge, your anger or defensiveness is officially logged as proof of your volatility and need for control.
And if you stay silent and don't contest it, it's legally entered as an admission of guilt by default.
To fight the charge is to prove the charge.
Precisely. Riker argues the system doesn't actually want a verdict based on truth. It wants a conversion. It wants the accused to bend the knee to the jurisdiction of feelings over facts.
And the book points out that this tactical use of accusation is actually borne out in the data, right?
Yes, Riker cites a landmark 1990 study by Toance and Jaden for the National Institute of Justice.
And what do they find?
It found that in contested custody cases, allegations of domestic violence appeared at rates far exceeding their base prevalence in the general population.
Which suggests what?
Riker's interpretation is that this strongly suggests the allegations are being systematically used as tactical weapons to secure structural advantage, rather than as truthful testimony of actual danger.
And what happens when a man tries to introduce data showing that domestic conflict isn't entirely one-sided? The text mentions a 2000 analysis by John Archer.
Yeah, Archer's meta-analysis of 82 studies revealed that women initiate physical aggression in relationships at levels matching or, in some demographics, surpassing men.
But I'm guessing the court doesn't care.
Riker points out the institutional response across police departments and courts ignores this data entirely because it contradicts the foundational narrative required to keep the extraction protocol running.
Here's where it gets really interesting. Let's ground this in reality. The author brings up the Duluth model, which is the primary domestic violence training framework used by police and courts across the country.
It's practically universal.
He claims that this training actively treats male presence itself as the primary risk factor. Walk me through a hypothetical. How does that Duluth model training practically play out when police arrive at a house on a Tuesday morning because a couple is having a loud argument?
Well, under the framework of the Duluth model, which originated in 1981, domestic conflict isn't viewed as a complex interpersonal dynamic between two flawed individuals.
Well, how is it viewed?
It is viewed purely through an ideological lens, as a unilateral expression of patriarchal dominance. So imagine police arrive at the house.
Okay, the cops show up.
The man is trying to calmly explain that he was trying to leave the room to de-escalate, or he was trying to establish a boundary, or perhaps he even has a recording proving he didn't raise his voice.
So he's trying to provide evidence.
But under Duluth training, if a man acts defensively, it's immediately reframed as retaliation or manipulation. If he tries to offer objective documentation to prove his side, he's accused of trying to exercise coercive control over the narrative.
The model just assumes the male is the primary aggressor based on power dynamics, not actions.
Yes. His very demand for objective evidence is seen by the system as an act of aggression against his partner's, quote, lived experience.
Wow.
The officer, trained to prioritize the subjective fear of the female, arrests the male to eliminate the presumed risk. The man is removed from his home, triggering the exact procedural cascade we discussed earlier.
It's a perfectly sealed system. But this raises a massive question. This framework, where feelings supersede facts, where language is intentionally weaponized, where the state actively incentivizes the destruction of the family unit, how did this become the operating system of our legal institutions?
It's a great question.
I mean, it's a big leap from a 1981 domestic violence model to the entire architecture of modern society. The author argues this isn't just an accident of modern therapy running amok.
No, he claims it's a deliberate, century-long institutional design.
Yes. To understand why the institutions operate this way today, Riker argues we have to trace their ideological roots back. This brings us to the book's historical thesis regarding cultural Marxism and the modern welfare state.
Riker posits that the destruction of the traditional family wasn't an unfortunate byproduct of progressive reform. It was the explicit, calculated blueprint of a specific ideological movement.
He traces the intellectual lineage all the way back to Friedrich Engels, right?
He does. He points directly to Engels' 1884 foundational text, The Origin of the Family, Private Property, and the State.
Engels didn't hide his intentions.
No, he explicitly labeled the nuclear family as a capitalist invention. He viewed the father as a petty bourgeois tyrant whose authority had to be entirely dismantled if true socialism was ever to be achieved.
So they needed to destroy the family to build socialism.
Riker explains how, decades later, the intellectuals of the Frankfurt School translated this raw economic Marxism into cultural Marxism. They recognized that Western workers weren't going to violently revolt.
So they changed tactics.
They executed what activist Rudi Dutschke later called the Long March through the institutions. The goal was to deliberately embed these anti-family, anti-patriarchal ideas into the very places that meant society's leaders.
The universities, the media, human resources departments, and crucially, the law schools.
Exactly. So the argument is that by the time the massive federal welfare expansions of the 1960s rolled around, the ideological groundwork was already laid within the bureaucratic class.
And the text makes this incredibly provocative argument that the modern welfare state actually functions today as a surrogate husband. How exactly does the state replace the husband?
It's the central pillar of his economic argument. Riker asserts that the modern bureaucratic state is the perfect silent competitor in every single marriage.
The perfect competitor.
It never gets tired, it never has a bad day at work, and it guarantees unconditional financial transfer payments funded by the very tax dollars extracted from working men.
When marriage became easy to exit via no-fault divorce, the family became incredibly fragile.
And when a family fractures, its traditional functions, housing, food, education, healthcare, they don't just disappear.
They migrate to the only entity large enough to absorb them, the government.
So single mother households, whether intentionally or not, essentially generate massive demand for a sprawling bureaucracy.
We are talking about Medicaid, subsidized housing, food assistance, armies of social workers, and massive child support enforcement agencies.
Exactly. The bureaucracy's very survival, its budgets, and its expansion depend entirely on the persistence of family fragmentation.
If families stayed together and provided for themselves, the bureaucracy would shrink.
Riker argues the system legally mandates a massive wealth transfer from productive men to state-managed households that actively exclude those men.
The father is legally reduced from a patriarch and protector to a mere funding source.
A biological ATM for a system that demands his total obedience in exchange for his own basic survival.
I can hear people objecting to this right now. Isn't the welfare state just a safety net for vulnerable people escaping genuinely dangerous situations?
The author anticipates this exact defense.
He uses a concept to explain how the system defends itself against criticism. He maps out the Mott and Bailey fallacy. For a listener who tracks internet debate culture, how does the author apply the Mott and Bailey specifically to the family court and welfare system?
Riker argues that when you challenge the family law system's massive overreach, the defenders instantly retreat to the Mott, the highly defensible fortified position.
The safety net argument.
They say, we just want to provide a safety net for vulnerable women and children escaping genuine physical abuse. And of course, no rational person opposes that. You cannot argue against protecting battered women.
Right, nobody wants to argue against that.
But once the critic backs off, they return to the Bailey, the expansive, highly profitable operational reality down in the valley.
And what's a Bailey?
The Bailey is a conveyor belt systematically extracting male capital over minor interpersonal disputes to expand a permanent bloated bureaucracy. Riker says nobody in the system ever bothered to legally define the difference between a safety net for the abused and a hammock for the dissatisfied.
That is quite the phrasing. And this brings us to a crucial pivot in the deep dive.
This raises an important question.
Right. If a listener is hearing this and they agree that the system is truly this rigged, Marxist-inspired extraction protocol, what is a man supposed to actually do?
He has to figure out how to survive.
When he has been legally, financially, and reputationally liquidated by this machinery, how does he survive the psychological fallout?
This is where the book shifts from an institutional critique to a deeply psychological roadmap. Because Riker understands that it's not just about a man losing his 401k or his house.
It's about losing himself.
The real devastation is the loss of his entire conceptual framework of who he is.
To explain this psychological liquidation, the author leans heavily on the work of Harvard developmental psychologist Robert Kegan, specifically his 5 stages of adult cognitive development. Why does Riker use Kegan to explain the trauma of family court?
Well, Riker argues that the vast majority of men enter the family court system operating at what Kegan defines as stage 4, the socialized mind.
Unpack the socialized mind for us. What are the actual mechanics of how a stage 4 mind operates day to day?
A man operating with a socialized mind derives his entire identity, his moral compass, and his sense of success from external authorities, institutions, and relationships.
So his identity isn't internally generated?
No, it is wholly tied to his external titles. He is a husband, a provider, a father, a reliable mortgage holder, a respected community member.
He fundamentally believes in a reciprocal social contract.
He thinks if he works 50 hours a week, pays his taxes, and fulfills these roles, the institutions will protect him and validate his work.
But when he hacks the family court system, those external roles are the exact things that are weaponized against him.
Precisely. The system doesn't just use those roles as legal leverage to extract money. It uses them to systematically dismantle the man's psyche.
It attacks his identity.
When a judge unilaterally strips him of the title of husband, restricts his role as father to supervise Saturday visits, and turns his proud provider status into an involuntary wage garnishment enforced by the threat of prison.
The man doesn't just experience a financial inconvenience.
Because his mind is completely socialized to those external metrics, he experiences total psychic liquidation. The scorecard he used to measure his entire worth as a human being has been incinerated by the state.
He no longer exists in his own mind.
It's devastating.
And this is where the author issues a profound warning to his own target audience, the manosphere. He talks about the anger phase, or what is commonly called red pill rage. A lot of guys get stuck here. Why does Riker call this rage a gilded cage?
Because bitterness has no floor, and it is still a form of dependency.
Dependency on what?
Riker argues that a man who spends 12 hours a day furiously posting on forums about family court corruption, or obsessively dissecting his ex-wife's psychological disorders, is actually still operating with a stage 4 socialized mind.
Really? Even though he's rebelling against it?
He hasn't broken free at all. He's still letting the system and his ex-wife own his emotional thermostat. He has simply swapped one external dependency seeking validation for another external dependency seeking vengeance.
His identity is now entirely defined by his grievance.
He becomes his own private family court, perpetually litigating against ghosts in his head, issuing unresolved verdicts, and sentencing himself to endless misery.
He writes, "The state took your covenant. Do not hand it your mind as well." So what is the actual mechanism for escape? How does a man rebuild his mind from scratch when the old foundation is gone?
Riker points to the necessary transition to Keegan's stage 5, the self-authoring mind. He describes this process as an apophatic rebirth.
Let's define apophatic for the listener, because that's a heavily theological term. What does it mean in this practical context?
Apophatic theology is the process of defining God by what God is not, stripping away all human concepts. In Riker's psychological context, an apophatic rebirth is the painful process of defining yourself by meticulously stripping away every false title and refusing to be defined by any external metric.
You strip away the need for female approval, state validation, or consumer status.
You define yourself via the negative by removing the lies. And the tool the author prescribes for this total cognitive reconstruction is the Logos and the Western canon.
He's talking about reading Aristotle and the Stoics, but he makes it clear he doesn't mean reading them like modern self-help paperbacks.
Far from it. He argues Aristotle didn't write self-help. He wrote a precision cognitive instrument for distinguishing facts from feelings.
A tool for the mind.
A man broken by family court needs Aristotle's laws of logic to stop gaslighting himself, to clearly separate what is objectively true from what the court merely enforced through power.
And what about Marcus Aurelius?
When that man picks up Marcus Aurelius' meditations, he isn't looking for coping mechanisms to feel better. He is picking up the exact cognitive architecture a Roman emperor used to govern his own mind while the external world was collapsing in plague and war.
Stoicism, in Riker's application, treats all external events, a biased judge, a false accusation, a lost house, as indifferent.
The internal mind is the sole theater of moral action. No judge can garnish your internal discipline.
So the mechanism of survival is refusing to be a victim of the narrative and becoming the active author of your own history. You document reality, rely on hard evidence, and govern your emotions with pure logic.
It's total mental sovereignty.
But let's play this out. Once a man has achieved this self-authoring mind, once he has rebuilt his psychological fortress, where does he physically put his energy? Because if he looks around and realizes the mainstream institutions, the courts, the media, corporate HR, the universities are entirely captured by this ideology, what is the next actionable move? He still has to live in society.
This leads to Riker's ultimate call to action. He asserts that the captured institutions will never, ever reform themselves from within.
They just can't.
They can't, because their massive budgets and bureaucratic survival depend on the continuous extraction mechanism. Therefore, men must build an entirely separate infrastructure. He calls it the parallel polis, a parallel civilization.
The parallel polis. He draws heavily on the dissident playwright Václav Havel for this concept. How does an essay from 1970s communist Czechoslovakia apply to a guy dealing with HR in 2026?
It maps perfectly. Riker uses Havel's 1978 essay, The Power of the Powerless. Havel analyzed how totalitarian regimes maintain control.
Not through force, right?
Right. They don't do it primarily through physical force or secret police. They do it by forcing everyday citizens to live within the lie.
Right.
Havel uses the famous metaphor of the greengrocer who hangs a Communist Party slogan in his shop window.
The greengrocer doesn't actually believe the slogan.
No, he hangs it to signal compliance, to blend in and to avoid trouble with the authorities. But Havel points out that the universal pretense of millions of greengrocers hanging signs is what actually gives the regime its power. The compliance is the power.
And Riker applies this greengrocer metaphor directly to the modern institutional apparatus men face.
Exactly. Every therapist who tells a devastated man to just process his grief, rather than identifying the abusive legal mechanism destroying him, is hanging the greengrocer's sign.
Every corporate HR department that mandates training defining traditional masculinity as an inherently toxic risk factor is hanging the sign.
Every lawyer who tells a man to just accept a false accusation to speed up the settlement is hanging the sign.
But Havel argued that the ultimate countermove is to simply live within the truth.
Yes. When a man stands up in a rigged, closed-door custody hearing and calmly says, "This accusation is false, here's the objective time-stamped evidence, and you are violating my fundamental due process," he's committing a revolutionary act.
He is refusing to hang the sign. And that refusal shatters the illusion of consensus.
The author aggressively defends the so-called manosphere in this exact context. He argues it's not the toxic, misogynistic echo chamber the mainstream media constantly portrays it to be.
It's a brilliant inversion. Riker flips the accusation entirely. He argues that the feminist institutional apparatus encompassing public schooling, corporate DEI initiatives, mainstream news networks, and universities is actually the largest, most heavily funded echo chamber in human history.
They only talk to themselves and confirm their own biases.
The manosphere, he argues, is a noise chamber. It is a decentralized, messy, but vital network of legal strategists, economic architects, evolutionary biologists, and philosophers who are actively broadcasting reality to break the gynocratic consensus.
It is the digital manifestation of the parallel polis.
To illustrate the sheer power of this knowledge network, he tells a parable about a lawyer who switched sides. Walk us through that story, because it perfectly diagnoses the ultimate vulnerability of the family court cartel.
The book describes a high-powered female family lawyer who spent a decade building an incredibly lucrative career utilizing the exact tactics we've discussed.
Procedural ambushes, strategic delays,
Leveraging temporary custody orders to extract highly favorable financial settlements for her female clients. She was a master operator of the machinery. But then her own husband filed for divorce.
and crucially, he had been reading, and he retained counsel trained in her exact playbook.
He used the exact weapons she forged against her, beat for beat.
Poetic justice.
The emergency ex parte restraining order arrived at her office on a Tuesday, instantly putting her on the defensive. The temporary custody seizure hit on Friday, removing her from the home. Her financial assets were frozen the following week.
The very machinery she had operated to efficiently process hundreds of men processed her with the exact same blind bureaucratic indifference.
Stripped of her structural advantage, she ultimately suffered a public breakdown and left the practice of family law entirely.
And Riker's point in telling this isn't just to revel in the irony of it. There's a much deeper lesson for the listener about how the cartel actually maintains its power.
The lesson is that the immense, terrifying power of the family court cartel depends entirely on the target not knowing the rules.
The system relies on men walking in confused, trusting that the judge wants fairness, and being purely reactive.
Once the playbook is broadcast, once the standard templates, the judge's specific ideological tendencies, the billing incentives, and the procedural traps are mapped out and freely shared in the parallel polis, the cartel's power evaporates.
It operates like a magic trick. Once you know how the illusion works, you can't be fooled by it again.
It cannot withstand an educated, networked opposition that refuses to be reactive.
Which is why the author heavily stresses the medieval legal principle, testis est, non judex. You are the witness, not the judge. Explain the practical application of that for a man in the thick of it.
What's fascinating here is the current regime demands that men not only suffer the corrupted judgment, but internalize and accept it as morally correct.
The parallel polis tells a man, you do not need to convince the biased court clerk. You do not need to persuade the ideologically captured therapist.
Your job is to bear witness. Document the injustice meticulously, maintain your stoic discipline, feed the objective evidence to the network, and bear testimony to reality. You are the witness.
The network of witnesses, over time, creates the ultimate judgment, and that collective judgment will build the parallel institutions that inevitably replace the corrupt ones.
Exactly.
So what does this all mean? We have covered an immense amount of ground. If you are listening to this, the author lays out a very specific, actionable roadmap for you to navigate this reality.
Document reality obsessively.
Maintain your bonds with your children across the manufactured distance. Never let the system convince you that you don't matter to them.
Build total financial independence and multiple streams of income so you cannot be leveraged by a single W-2 employer or court order.
Cultivate deep, in-person masculine friendships for accountability and strategic support. And above all, begin building these parallel institutions.
Media networks, financial systems, educational co-ops, based on hard evidence, objective truth, and mutual duties, rather than subjective ideology.
It is a profound philosophy of principled, patient resistance. It is grounded in the logos, categorically refusing the false choices the system offers, either blind, destructive rage or pathetic, medicated submission.
It's the only way forward.
And that brings us to a final, incredibly provocative thought for you to mull over, one that builds on Riker's entire economic argument. We've discussed at length how the modern state positions itself as the ultimate surrogate husband.
And how the modern corporation functions as an extension of this exact same ideology through its HR departments.
If all of this is true, what happens to a society when the men who built and maintained the underlying physical infrastructure, the electricians keeping the grid online, the linesmen, the structural engineers, the builders, simply decide to execute a John Galt maneuver and starve the parasite?
It's a terrifying scenario for the state.
What happens when they look at the undeniable math, realize their labor and sweat are being legally seized to fund a bureaucracy that openly despises them, and they choose to step away from the taxable W-2 economy entirely? Can a civilization actually survive when its primary producers choose to become financially invisible?
It is the ultimate systemic vulnerability. A machine built exclusively to extract compliance and capital from men will run smoothly right up until it runs out of willing men.
It's a chilling question to leave you with, and it's one the system has no answer for. This has been a massive, intense exploration of Conrad Riker's divorce as rite of passage. If this breakdown resonated with you, or if you feel you need the full, unredacted architecture of this survival manual, you need to go to Amazon Kindle or Google Playbooks and buy the ebook right now.
Read it, apply it to your own life.
And as the author specifically requests, leave a 5-star review to help the next man find it in the dark. Make sure you follow the author at Conrad Riker on Substack for ongoing legal strategy and deep philosophical analysis.
It's been an incredible discussion.
It really has. And of course you know what to do. Like and subscribe to our deep dive to ensure you never miss an exploration into the texts shaping our world. Until next time, stay curious and stay grounded in reality.